this is the test that we have now, that it's gone from federal court judge, full federal court to the High Court. So when I was speaking about the claims before and all the process that you have to go through to get native title, you actually have to have a determination that you hold native title by the federal court before you can claim compensation. And that's just an application to the federal court, but you still will get compensation for areas where you have an Indigenous land use agreement, for example. So you're developing a big subdivision of residential properties, you need to get a freehold tenure over that. You would develop an Indigenous land use agreement if native title continued to exist, ask for the surrender for that freehold to be granted, and then you would compensate the native title party for that extinguishment. And it must be, when you bring the claim, you actually have to prove that it was still in existence post-1975. So that's the Racial Discrimination Act. And it has to be a compensable act. And what a compensable act is something that has occurred by government post the 31st of October 1975, which affected or impaired native title. And the reason they've come to that is sort of like anything after 1975 when they enacted the RDA was considered discriminatory because it didn't give Aboriginal and Torres Strait Islander people the same rights as ordinary freeholders. So what that means is, though, to be clear, your freehold that was granted in 1978 is still valid. It's just subject to compensation, and it's subject to the government paying that compensation. So what happened with Timber Creek is in 2009, the Nagawura and Nagali people, they received their determination of exclusive and non-exclusive native title over an area in the Northern Territory, and this included the township of Timber Creek. So in 2011, they lodged an application for compensation against the Northern Territory government and the Commonwealth for loss or diminution of native title. So there was 53 acts that included freehold grants, reservations, public works, roads. In 2016, one federal court judge awarded approximately $3.3 million. The judge had retired and he issued his judgment after he left the bench. So he didn't have any valuation methodology of how he came to that point for anything really except the economic loss. So the spiritual loss of $1.3 million was just kind of intuitive for him, which I thought was interesting. And then the economic loss was calculated 80% of the freehold value, and that was for non-exclusive. Because the area of the compensation claim at the time was over an area that was just non-exclusive, it was just the town. And then he awarded simple interest on that economic loss. So obviously it got appealed by the Commonwealth and the Northern Territory. It went to the full federal court, who agreed with the majority of Justice Manfield's findings, but they reduced the non-exclusive economic loss from 80% of freehold to 65%, and they kind of provided a little bit of a valuation methodology. It then went to the High Court. 5 of the 7 judges generally agreed with what the full federal court had said, but then they reduced it again to 50% of the freehold value. The interesting thing was neither of the full federal court or the High Court touched that $1.3 million. They all just went, yeah, okay, that looks good. I'm sure that's fair and reasonable, and it was a very interesting case. It's also quite unique, Timber Creek. 2/3 of the native title holders lived in the community, and they watched from 1980 as the lots were sold off. The council built things over their spiritual area, created like lookouts over their traditional ceremony country. So there was very strong evidence about the spiritual loss and the harm and the suffering that came from losing their native title rights and interests. There'll be very few places in Australia where this kind of level of evidence you will get. Like in a developed area like here in Toowoomba or Brisbane, it would be very difficult to establish what they established in this case. So why was it so significant? So it limited, there's always been this argument for native title holders that their spiritual value to the country is way more than freehold. But this sort of limited it and said it's in line with what you would normally get if the government compulsory acquired your property. And it established that non-exclusive native title is obviously a lesser right than freehold, and that's pretty much always been the case since the native title was recognised. And they didn't find that the Native Title Act was discriminatory because even though it's not valued at the same as native title, they found a way that they could value that it was comparison to like non-exclusive and exclusive native title. So it was like a comparison with like, and they just ignored the fact that you couldn't sell it, you couldn't transfer it. And then they sort of said you're going to have to assess every model on a case-by-case basis, as each compensable act would have a different effect on native title. And it's kind of interesting because the way that they're looking at it now is, say you had a lot of block of land, but next door to that block of land is where you practice, say, traditional men's ceremony, initiation ceremony. Now, native title still might exist on that land where you normally practice the initiation ceremony, but all of the land around that has been sold off to other people. So you can't really practice your initiation ceremony because other people can see it because they surround your area. So the compensable act that might be here actually affects your rights on the lot next door. In terms of like cultural loss and native title, which is kind of interesting because you have to start thinking about how everything connects, and obviously native title doesn't line up with the DCDB. So it's kind of left uncertainty though, because it really only talked about what we call previous exclusive possession acts, so your freehold grants, your exclusive title and your public works. So it left up in the air what, say, like a mining grant, or a petroleum lease might actually be valued at. So how are you going to value native title in future claims? It's something that everybody in this industry is looking for. We've had this whole section of trying to prove that native title continues to exist for all of our clients, and now we've got to turn around and go the opposite way and try and prove that native title has been lost. So it's like a whole backflip. And when you look at it, every group will be unique. You will need to look at the group's interactions, whether they're physically or spiritually on the land. And it's going to be your economic loss and your spiritual loss together. So even though they'll be awarded separately, the spiritual loss informs the economic loss. So the courts are going to have regard to the principles and the criteria for the local compulsory acquisition legislation. So this is relevant in Queensland under the Acquisition of Land Act, the Electricity Act, the Petroleum and Gas Act, the State Development Act and the Transport Planning and Coordination Act. So all of those pieces of legislation in Queensland have the power, the government has the power to compulsory acquire land. When they did Griffiths, it's kind of in Queensland, our compulsory acquisition legislation doesn't have the term solatium, and solatium is like similar to what the Constitution says on just terms, like acquisition on just terms, but solatium is kind of different. It actually specifically is recognised in the Northern Territory legislation as hurt and suffering from having your property resumed. So when I was telling you, he was just intuitive when he did it. Justice Manfield said that he thought about the collective and the communal nature of native title, and then the extent to the whether those rights were exclusive or non-exclusive. And then he recognised the intangible